On Monday, August 17, 2026, the Supreme Court closed out a legal fight that had already run for more than 7 years, denying President Trump's final request to reconsider a case he had already lost, unanimously, without a single noted dissent. The money at the center of this specific fight, $5.6 million, had actually already been paid to E. Jean Carroll months earlier. What Trump was asking the court to do was let him claw it back. Today we are walking through the complete timeline of this case, from Carroll's original allegation in 2019 through this final unanimous denial, because the sequence here spans 2 separate lawsuits, multiple appellate rulings, and a specific legal maneuver worth understanding clearly rather than as a single flattened headline. Before we get into the details, if you want to follow a long-running legal saga like this one through its actual sequence rather than catching only the final ruling, hit subscribe, because cases like this one often take years to fully resolve, and understanding how they actually got here makes the final outcome make far more sense. Let me know in the comments once you have heard the complete timeline whether the length and complexity of this legal process surprises you, because I think it says something real about how difficult it actually is to finally close out a civil case at the highest level of the federal court system. Let's start at the very beginning. In 2019, writer E. Jean Carroll publicly alleged that Donald Trump had assaulted her in a dressing room at Bergdorf Goodman, a Manhattan department store, in the spring of 1996, describing an encounter that began, according to her account, as a friendly interaction before turning violent. Trump denied the allegation, responding at the time by saying Carroll was not, in his words, his type, comments that prompted Carroll to sue him for defamation later that same year. That first lawsuit became tangled up in complicated legal questions about presidential immunity for statements Trump made while in office, questions that took years to fully sort out in the courts, since determining whether a sitting or former president can be held liable for comments made in that official capacity is itself a genuinely difficult constitutional question courts had to work through carefully. While that first case remained tied up in those preliminary legal disputes, Carroll filed a second lawsuit in 2022. This one brought in part under New York's Adult Survivors Act, a state law that created a limited window allowing survivors of older sexual assault allegations to bring civil claims that would otherwise have been barred by the statute of limitations, recognizing that survivors of this kind of assault often take years or even decades before feeling able to come forward. This second lawsuit combined a sexual assault claim with a new defamation claim based on comments Trump made in October of 2022 after leaving office, in which he called Carroll's allegations a hoax and a con job. Here is where the timeline gets a little counterintuitive. Even though Carroll's second lawsuit was filed after her first one, it was the second case that actually went to trial first, in 2023, because it was not tangled up in the same presidential immunity questions, still working through the first case. At that 2023 trial, presided over by Manhattan-based federal judge Lewis Kaplan, a jury found Trump liable for both sexual abuse and defamation, though notably not for rape specifically, a legal distinction the jury verdict itself drew explicitly. The jury awarded Carroll $5 million in damages. Trump appealed that verdict to the United States Court of Appeals for the Second Circuit, and his legal team raised several specific arguments. They argued Judge Kaplan should not have allowed testimony from 2 other women, Jessica Leeds and Natasha Stoynoff, who separately accused Trump of similar sexual misconduct incidents, one in the 1970s and one in 2005. Testimony Trump's team argued had unfairly prejudiced the jury against him by suggesting a broader pattern of conduct beyond what Carroll herself had alleged. Trump's legal filings also argued that Carroll had deliberately waited until he was president to bring her claims in order to, in the filing's own words, maximize political injury to him and profit for herself, and his team separately noted that Carroll had never reported the incident to police at the time, and that there were no eyewitnesses to corroborate her specific account. In December, a 3-judge panel on the Second Circuit rejected all of these arguments and upheld the jury's verdict in full, finding no basis to disturb either the trial's evidentiary rulings or its ultimate outcome. Trump then asked the full Second Circuit to rehear the case, a broader form of review that goes beyond the original 3-judge panel to the entire bench of that appellate court, a request the appellate judges denied in June of 2026, exhausting his options at that level of the federal court system entirely. That left Trump with a choice: accept the outcome or take the case to the Supreme Court. His legal team chose to pursue Supreme Court review, and in June of 2026, the justices declined to take up the case, issuing a brief, unexplained order, which is standard practice when the Supreme Court simply declines to hear a case rather than actually ruling on its merits. That denial left the 2023 jury verdict and the Second Circuit's rulings upholding it fully in place. Following that denial, Judge Kaplan, who had presided over the original trial, ordered the funds Trump had previously paid into a court-controlled escrow account to actually be released to Carroll. This is where the specific legal maneuver at the center of this particular news story actually begins, and it is worth understanding it as a distinct procedural step separate from the merits of the underlying case itself. Trump argued that releasing those funds to Carroll had been premature, because he still had a separate petition pending at the Supreme Court, this one asking the justices to reconsider their own June decision not to hear the case, a request commonly called a petition for rehearing, a genuinely uncommon procedural step since the Supreme Court grants such requests only very rarely. Trump's legal team asked the Second Circuit to order the funds pulled back into the court-controlled account or potentially refunded to Trump entirely, while that rehearing petition remained pending before the Supreme Court, effectively asking a lower appellate court to undo a distribution that had already been completed based on the possibility that a higher court might still change its mind. The Second Circuit, weighing that request, decided to hold off ruling on it until Tuesday, specifically because the Supreme Court itself might act on the pending rehearing petition first, which would resolve the underlying question before the appeals court needed to weigh in at all. A sensible sequencing choice given how directly the Supreme Court's own action would determine whether the clawback request had any remaining basis. On Monday, the Supreme Court did exactly that. The justices denied Trump's petition for rehearing, with no noted dissents from any of the 9 justices, finalizing their earlier decision not to hear the case at all. That denial effectively rendered Trump's clawback motion at the Second Circuit moot, since there was no longer any pending Supreme Court proceeding that could justify pulling the already distributed funds back out of Carroll's control. The practical result is straightforward. Carroll keeps the $5.6 million, a figure that reflects the original $5 million jury award plus interest that had accrued in the years since the 2023 verdict, and this specific line of litigation is now fully and finally closed. There is one detail worth being precise about before wrapping up, because it is easy to conflate 2 related but genuinely separate cases. This entire fight, the 2023 trial, the $5 million verdict, the appeals, and this final rehearing denial, involves Carroll's second lawsuit, the one brought partly under New York's Adult Survivors Act. Carroll's original 2019 defamation lawsuit is a separate case entirely, one that eventually produced a much larger judgment, $83.3 million, after a different jury trial addressing different specific statements Trump made about Carroll. That larger judgment remains a separate, ongoing legal matter with its own appeals process that this particular Supreme Court action did not resolve or touch in any way. If you have seen headlines mentioning both dollar figures together, it is worth keeping straight that these are 2 distinct verdicts from 2 distinct lawsuits, moving through the court system on their own separate timelines. Step back and look at what this entire 7-year saga actually demonstrates about how a serious civil case works its way fully through the American legal system. Carroll's allegation became public in 2019. It took until 2023 for a jury to actually reach a verdict on her second lawsuit. It took until 2026, 3 more years, for that verdict to survive the full appeals process, a Second Circuit panel ruling, a request for full court rehearing, a Supreme Court cert petition, and finally a petition asking the Supreme Court to reconsider its own decision not to hear the case. Each of those stages represented a genuine opportunity for the outcome to change, and at every single stage, spanning multiple different courts and multiple different panels of judges, the original jury's finding held without exception. That is what a fully exhausted civil appeal actually looks like in practice, a process considerably longer and more procedurally layered than a single trial verdict alone might suggest, involving years of additional litigation focused not on whether the underlying facts were true, but on whether the trial itself had been conducted fairly enough to let that jury finding stand. If walking through the complete timeline from the original 2019 allegation through this final unanimous denial gave you a clearer picture of how this case actually resolved, hit that like button so more people understand the full sequence rather than just the final headline. Subscribe because Carroll's larger, separate $83 million judgment still has its own ongoing appeals process worth tracking, and I will cover that case as it continues to develop. Drop a comment telling me whether the length of this entire process, over 7 years from allegation to final resolution on just one of the two lawsuits, changes how you think about how the civil justice system actually handles cases at this level of scrutiny.